Revolution of common sense.
Revolution of common sense.
A revolution of common sense.
Truth was once common sense, but today, truth is uncommon. Explore biblical truths around faith, business, and politics with Peter Demas. Uncommon sense in current times.
Hey folks, welcome to Uncommon Sense in Current Times. I'm excited to be joined by former Representative Louie Gohmert. We're here to discuss the possibility of impeachment with judges that are there. As we've seen the Trump administration push for reforms through DOJ and through immigration and different things, we're seeing members of Congress and a lot of federal district judges are blocking this, and we're seeing a lot of members of Congress calling for the impeachment of judges that might have overstepped their bounds. So I wanted to speak with somebody who is uniquely qualified with this. Congressman Gohmert is an influential figure in the Tea Party movement. He has served as Texas' 1st District from 2005 to 2023, was a former state judge, Chief Justice on the Texas 12th Court of Appeals, sat on the House Judiciary Committee where he actually dealt with a couple of judicial impeachments himself. And so, Congressman, thank you so much for being on the show. I greatly appreciate you being here.
Great to be with you, Peter. Thank you.
So what specifically do you think is the core problem with the current judiciary that you think calls for impeachment issues?
Well, I've seen it develop over the years in recent decades, and I do mean plural decades, that you had judges that would get more and more vicious from the bench without being called down for it. And they would get away with it, and they would get more and more vicious and more partial from the bench without being called down for it. And you mentioned that I was on the Judiciary Committee when we had a couple of impeachments back in 2009 and 2010. And even during those, the standard was considered to be that you had to prove that a federal judge committed a high crime or misdemeanor. And actually, Peter, that is the standard under Article 2 of the Constitution as pertains to executives. And I'm sure your listeners, they wouldn't be listening to you unless they're really tuned into the Constitution. And they understand Article 1's about the legislature, the Congress, House and the Senate, and Article 2 is about the executive branch. And that's where in Article 2 it talks about impeachment if there's been a treason, bribery, other high crime or misdemeanor. And then Article 3 talks about the judiciary. And the Constitution only creates one federal court, only one, the Supreme Court. And as my constitutional law professor used to point out, all other courts, federal courts of any nature, are created by Congress. Congress brought them into the world. Congress can take them out. Congress can set their jurisdiction. And it's in Article 3 that you have the language very clear. And it says that the judges, both of the Supreme and inferior courts, shall hold their offices, and here's the operative language, during good behavior. Now, people say all the time, oh, well, those federal judges, they get lifetime appointments. That's not what the Constitution says. It says they have those offices during good behavior. And what we've been seeing is worse and worse behavior. And during my 18 years on the Judiciary Committee in Congress, we were in the majority a lot of that time. And I would be telling people, we really need to bring some of these judges in and put them on the hot seat and question them about their bad behavior. That's what Article 3 talks about. And well, I don't know if we want to open Pandora's box. Well, it's not opening Pandora's box. It's being responsible for what the Constitution requires us to do. Uh, and besides, so what if we're not in the majority and Democrats decide to bring justices in or judges in and question them about their good or bad behavior? But I mean, some of this behavior has just become so outrageous. It needs to be questioned, and judges need to be there. But what happened during those years, the best we could get Republican chairs to do, and these were good people, really wanting to do well, and they had to answer, unfortunately, to some speakers who were not good speakers. Boehner, Paul Ryan, then eventually McCarthy, but they didn't really want to take any of these issues on too strongly. And so they will just call in experts and let the experts talk about how bad their conduct is. Well, no judge was ever intimidated by that, and they won't be until you bring the judge in and start questioning them personally about their bad conduct, of their bad behavior.
All right, so I got a couple of questions because my understanding is the way the Supreme Court has never really dealt with the issue of good behavior. I mean, they've
No.
addressed it a couple times. I know there was a case back in 1920 where they reference it, but it was kind of referencing it in the basis of just they're going to be around for a lifetime. Like that was more of
Yeah.
the way to phrase that for that, and it's kind of pretty much set its tone from that. However, the concern that I have, and I guess what I want to ask you is who defines good? Because if we look at the Pelosi's Congress that was there, right when you started, roughly, back in that time period, when they kind of rammed down Obamacare, they rammed down a lot of this stuff. For them to pull out some of these traits to say what is good and what is bad, that seems concerning to me. That's there, not necessarily the fact of should we call them out on it, but I'm wondering should we politicize? There's a danger of politicizing impeachment, as we've seen with the president several times in his first term and potentially the second one.
Yeah, well, there's only been three presidents that have been impeached, and President Trump is one, and he's been impeached twice,
Right.
and they're both total politizations. And you look at the warfare, the lawfare that's been waged against him. The courts have been totally politicized. So
But do we want to
got
do that
make
to our
use of
judges
those while
too?
we got the chance. And yes, Peter, I totally understand your point, and that's been the concern of some chairs of judiciary and some speakers. Oh, that's maybe opening Pandora's box, but the problem is we have to deal with this issue. And yes, Pelosi and now Hakeem Jeffries
Mhm.
to a lesser level in my mind, but they totally politicize most everything. But that's why the Senate is there, and it requires a two-thirds vote to remove someone. So I think it's still appropriate, at least to subpoena a judge and bring them in and talk about these issues. I think their bad behavior has gotten so prolific that it has to be done. They have to be held accountable. And Chief Justice John Roberts has shown he is either incapable or unwilling to deal with the truly bad behavior.
So there are other ways, though, that Congress can bring them in, correct? Through ethics committees, through I forgot the act that it's there that basically holds judges accountable to certain judicial standards. I cannot remember the name of it. It's like the Judicial. Hold on, I have it written down here. The Judicial
Yeah.
Conduct and Disability Act that was passed in 1980. So is impeachment all that's left to bring it in under that category? Because the history the history of it, we've only had like 14 impeachment upon judges throughout the history of the United States, and a couple of them they were acquitted, and one of them was very political back in the early 1800s.
Yeah.
So should we be using the Judicial Conduct and Disability Act more instead of jumping straight forward into an impeachment type process?
Well, the problem with the procedure of allowing the bar or allowing the judiciary to police itself, they haven't done that. They haven't done so. They haven't policed themselves. They set up standards, and even under their standards, uh, a judge should recuse themselves when there is a chance of the appearance of any partiality. And they haven't done that. They haven't enforced that. They've let that run amok. And Chief Justice John Roberts has done absolutely nothing to enforce that. And so it's clear that even though Congress has allowed them to to control themselves, or just like Congress has allowed the District of Columbia to have home rule and to rule the city themselves, that isn't going very well. But it doesn't mean that Congress can't step in at any time and fix things that DC is not dealing with themselves, and the same way with the judiciary. It doesn't mean that we have given up our right and our power to step in and say, look, we've given you a chance to control your ethics. You have not done so. But this the bill that was passed in 1948, that includes a provision about recusal, it has not been followed whatsoever. And that was Beryl Howell was a good example of that last week when she made a mockery of it, saying in response to President Trump's motion to recuse that she was so familiar with the requirements of recusal, and this does not require disqualification whatsoever, when actually the law that was created, which Congress had every right to create, makes very clearly if there is even the appearance of potential lack of impartiality, she had to step down.
Right.
She shall disqualify herself. And so either she's lying or she's just completely ignorant of what the law is. And in either case, she needs to be removed. And there is no indication whatsoever that Chief Justice John Roberts will remove her. And so that's why Congress has to go ahead and step in and take action, because it's not happening from any other source.
So you've referenced, judges not being good. You referenced good behavior. You referenced, I think vicious was one of the words you used. How are you defining this behavior? Because somebody who doesn't recuse themselves when they should, and I agree with you completely. They ought to. As an attorney, you don't want to go up against a judge that you know is. I mean, it's difficult enough as an attorney not knowing what a judge is going to do in spite of facts anyway. But when you do that, when you have that issue in front of you, is that considered enough to be kind of good behavior? Because I mean, the ones that I know that you said on, I think one was like filing false documents. There was a bribery case. Something with sexual assault was kind of in the middle of one of them as well. That to me, I can easily define as not good behavior.
Well, they were crimes, actually.
Yeah. So I mean, to me, that's this pretty simple line right there. But then again, there's that gray area as you're moving from easy crime, bad behavior to somebody saying that, well, Elon Musk did this number, so therefore he's a Nazi and therefore he's bad. I mean, so there's a line between here and here. And that line has to be drawn in order for Congress to step in order for the judges to know what they're doing, in order for it to not turn into this circus. Where do you define that line? How do you draw that distinction?
Well, I don't think there is a fine line that's drawn, and I think that is part of the genius of the founders. When it came to the executive branch, they realized, you know what? Um, they may elect some people that are less than honorable. Uh, and so we're going to say if you want to remove somebody that's been elected like that, basically they have to have committed a crime and you've got to be able to show it. You got to be able to prove it and convict them in the Senate for doing that. But when it comes to judges, we want more righteous people than that. Back to Leviticus, they shouldn't show preference to the poor or to the rich and mighty. They need to be righteous and just right down the middle. And we've got too many judges that simply are not. And they refuse to recuse themselves. And going back to my days as a judge or chief justice, we would go talk to other judges, if we thought, there may be a hint of, I had a death penalty case and there was no legal basis for disqualification, but the murder occurred 3 blocks from my house. And so and the case ended up in my court. I was afraid just from the geographic location that there might be questions later. And so just to remove any chance that that issue might come up, I said, there's no legal legitimate basis for disqualification. There's no ties there. But just so it won't be any possible issue down the road, I'm going to recuse myself and let another judge take the case. And that's what I did. That's what we do. You want to make sure not only is there no partiality, but there's not even the appearance of partiality. And that's not what's been happening in federal courts, especially in the DC circuits, the DC trial benches. And I don't know where Mike Johnson got the numbers, but it is staggering to think that 92% of all of the injunctions against President Trump have come from Democrat appointed judges, and that 62% of all injunctions against all presidents for the last century have been against President Trump. These are activist judges that have got to be reined in. And that I go back to the genius of the founders. They were saying, you know what? We're going to make it easier to remove judges than to remove executive officers. We're going to just say, let the Senate decide what's good and what's bad behavior. And actually, you mentioned a couple of judges. Actually, in 2009, there was a Florida judge that was impeached because of a case involving bribery, as I recall, if I recall correctly. And so he was considered not to be fit to sit on the federal bench. So he left and ran for Congress and got elected. And so one of the conversations that came up, that was before I got to Congress. So what came up in 2009 and 10 when we were looking at impeaching a couple of judges is, do we want to run the risk that we impeach them, remove them from the bench, and they turn around and run for office and end up in Congress?
Right, right.
So, there was a higher standard that judges should be held to. and a lower standard that members of Congress were held to. You could get elected to Congress no matter what you may have been guilty of in the way of a crime. So that, I think, goes back to the genius of the Constitution and those that put it together.
Okay, let's look at this logistically though. So because currently right now there's an injunction. The injunction could be appealed. And for those that don't know this, it goes appeal to the Court of Appeals. Then it can be maybe gone to the Supreme Court. There's a lot of decisions and guesses on sometimes which cases they take, which cases they don't. But for the most part, that's the general simple rule of this. Now, if there was this situation, there's an injunction, we feel like there was a conflict of interest, then Congress gets involved and they say, hey, we're going to impeach the judge. Well, meanwhile, that injunction's still sitting there until we go through the process. And then once you have that happen and Congress, and let's say Congress says, wow, you should have recused yourself. You're sleeping with the prosecuting attorney. I mean, something really obvious. At that point in time, then
your family's making a lot of money off.
Which is more common, which is actually happening a lot frequently now.
Yeah, right.
So then, but they have an opportunity to appeal that impeachment. At that point in time, they have an opportunity to do it, and impeachment doesn't necessarily mean removal. So there seems to be like all we're doing is just creating another step in the process logistically. Am I correct in that? Is there a way around that?
I think once the Senate votes to remove a judge, they're removed.
Okay. So
I'm not aware of an ability to go get unremoved once you're voted out by the U.S. Senate.
So in the situations where impeachment has been challenged in the Supreme Court and the Court of Appeals all the way up, and again, they have not heard all the cases. In those situations where they've talked about it, is that more not in the particular situation, but more of a broad stroke? So whether they can do it in this, whether it's considered a high crime, where does that fall? Because obviously it's had to have conversation at the higher court level to have rulings on it from that level.
Well, I'm not sure. I think the Supreme Court, they have had pretty well a hands off. And I hadn't seen the article, but I remember seeing John Eastman had quoted some story back that when a couple of the Supreme Court justices were saying that we have got to take up these election cases. We have got to. This is absolutely too consequential not to take them up. We've got to. That the story that was going around was that John Roberts had said, but if we do, they'll burn our cities down. We can't take them up. That he was more concerned about some activists burning cities like they did in the summer of 2020,
right,
than actually following the Constitution, which makes him, and that was the story back with why he changed his opinion at the very last minute and chose to uphold Obamacare rather than strike it down, is that the White House put pressure that if you strike this down, you will, for the rest of history, be seen as the most political Chief Justice since Chief Justice Taney wrote the Dred Scott decision.
right.
So he changed his decision, which in my mind made him the most political Chief Justice since Chief Justice Taney wrote the dreadful, pitiful Dred Scott decision.
So, all right, now I love that analogy of it. So, because again, the pressure put on them, and we know that the Supreme Court needs to remain independent, needs to remain unpoliticized, which again, we know they are. But I mean, and we've seen that throughout going all the way. The Brennan court was, when Brennan was on the court, and the Warren court when Brennan was on there, and Douglas and all them. That was They created a whole lot of bad laws that we're dealing with. But from that and from the perspective of it, if the president can put pressure on them and president can put pressure on Roberts, could the same not be said about the Congress, where Congress calls up and says, hey, if you don't do this, we're going to impeach you? Is that also a fear that could happen as well?
Yeah, I don't think Congress can call up and say that. I'm not, but uh, I guess it's possible somebody might, but they might do it uh, like Senator Schumer,
Right.
standing in front of the Supreme Court and announcing that that Kavanaugh was going to reap the whirlwind, however he said it. He made clear it sure sounded like a threat to me that they were coming after him. Uh, so to have a U.S. senator, especially one about to be majority leader, to stand out there, or he may have been majority leader at the time, but threatening a U.S. senator, yeah, it's pretty rough. It's not a good look, but there are so many things that have put our republic in jeopardy uh, that have to be dealt with. But one of them is these out of control district judges. But obviously, Peter, one of the things that Congress can do is say that on any matter that will affect a nationwide injunction or create a nationwide injunction, that has to be heard and decided uh, at the Supreme Court level. It cannot be heard at a district level or at the Court of Appeals level. And just take the lower courts out of it. Congress has the authority to do that. We could do that and should do that, I think. Just throw it in there, right in their court. Uh, and, some of these decisions, they need to understand there will be dire consequences. Um, Back when they were deciding that we might have to release all the people from Guantanamo, I was pointing out at the time they had a big fence around the Supreme Court where they were doing construction. I said, well, then maybe the answer is go ahead and bring them up and put them inside that big fence around the Supreme Court and keep them held there.
Right.
But that'd be a good place for them if they feel like they can't be held there. But by the way, I've been to Guantanamo more than once, and I've toured a lot of prisons, and that's a really nice facility. And yeah,
I've heard that from multiple people who've been there. They've said that. So we're nearing the end, and I've loved this conversation because it's something that I love. Kind of talking about kind of the Constitution. A lot of people love the Bill of Rights, but they kind of ignore the first several articles in there. So I appreciate being able to have this conversation with you.
Well, you ask good questions.
I appreciate it. So is it also possible, and again, I kind of look at it from, I remember Andrew Jackson reportedly said, it's attributed to him anyway, in the Webster case, well, the Supreme Court's made their decision, let's see them enforce it. What would happen now if Trump had that approach outside of the fact that everyone will call him a dictator, outside of the public, I mean, that they're already doing anyway. But on these injunctions, if he's just like, okay, we're going to do it anyway, is that a dangerous precedent as well? And do you think that having Congress oversight over the impeachment or over the removal of judges for conflicts, which do you think is probably the wiser way to go?
With regard to impeachment, I think, following what the Constitution said for impeachment of judges, they serve during good behavior. I think that's one way to go. Another is to restrict their jurisdiction so that they can't do these kind of things. But another is if you remove some because they are clearly very biased, very partisan, and enforce the 1948 statute on recusal, then I think
Right.
that will clean up. And you make it clear that you ask about a line, Peter. If Congress makes very clear that is a line we are not willing to move. If you are so biased and so bigoted against a party that comes before you, you can't hear that case, and we will remove you from the bench for doing so. That's a line we're not going to move beyond. Then I think that's a line we're standing on and not moving on, and I think that's one that should be stood on. But otherwise, with President Trump, they appealed to the Supreme Court on the order about removing the dangerous gangs and asking the Supreme Court to rein these courts in. And we'll see what we'll do. So he is following the procedure on that.
All right. Well, I appreciate this conversation. Again, I've absolutely love having this conversation with you. I'm not 100% on board with the impeachment piece, but I love your idea of restricting it, drawing that line on the recusals. Easier written than said. And so, but anyway, I think, but I do agree with you. We definitely have a problem, and we got to do something about it. So I thank you so much for speaking out on it, talking about it. When people want to know more about you, kind of what you're doing, where do they find out stuff for you?
Well, at Rep. Louie Gohmert on X, but I am a senior fellow with the David Horowitz Freedom Center, and publish articles at Front Page Magazine. But yeah, to reinforce, I think that's a clear line there on recusal. And if we remove people for not recusing themselves and say that is bad behavior, I think you'll see a lot of judges say, you know what, I am so partisan on this issue, I'm going to let somebody else handle it. And then we will get justice back under control.
I agree completely. Well, thank you again. I appreciate it, Congressman, and let me know if there's anything else that we can do to help.
Well, thank you. You're doing it right now.
All right, thank you.